Yes.
Good morning, my lords. I appear together with Jack Rivet for the original petitioner, Saxon Woods Investments Limited. My learned friends Lord Wolfson and Patricia Burns appear for the first respondent, Mr Costa.
Yes.
As your lordships are aware, both sides bring appeals against the judgment of Simon Gleeson, sitting as the deputy of the High Court, handed down on the 22nd of February 2024, almost exactly 1 year ago. The order consequential upon that judgment was made on the 17th of April. My lords, Lord Wolfson and I have discussed and agreed a broad timetable, obviously subject to your lordships. It's not intended to be a straitjacket. The key point being we each have equal time overall. In short, the idea is that I go first and I introduce the case and present Saxon Woods' appeal. My learned friend will then follow, presenting his appeal and responding to our appeal. And we then have one more go each, essentially. Yep. And I hope that's satisfactory.
Yes, thank you. It is. You were kind enough to let us know what you'd agreed, and we all looked at it, and it's fine. Thank you very much for doing that.
Thank you, my lord. In terms of bundles, there is a core bundle, a core supplementary bundle, and a supplementary bundle. Whilst the nomenclature is somewhat unusual, I hope your lordships do have those bundles available. In terms of housekeeping, someone is behind the scenes, as I understand it, looking after the transcript. So the normal practice, I understand, is for there to be a mid-session break, even though they are remote. So I would propose to break roughly for 10 minutes at about 20 past 11, and then in the afternoon again at 20 past 3 or so.
Yes. You say there's a core bundle and a supplementary bundle and another supplementary bundle?
Yes, there's a core supplementary bundle, which is certainly in terms of the hard copy is 1 volume, and then there are 2 volumes of what is called the supplementary bundle.
Yes.
It's a little bit confusing, but I think the intention was to try and stick to the rules as best we could.
Yes.
In terms of the additional documents that would be available to the court.
Yes, because I've been working from entirely from digital files. I haven't opened a hard copy. And I've got the core bundle, and I have a consolidated appeal supplementary bundle running to 1,312 pages.
That's probably what I'm calling the supplementary bundle.
Yeah.
So it sounds as if you have exactly the right files.
Thank you.
So without further ado, I was going to move to introduce the case. The background of these proceedings are obviously set out in the judgment. On our appeal, with the exception of ground 5, and to a limited extent grounds 1 and 2 of our grounds of appeal, there is no appeal against the findings of fact. For his part, Mr Costa has no permission to appeal in respect of factual matters. So for the purposes of these appeals, it's appropriate largely to adopt the judge's exposition of the background facts and his financial findings. And of course, those are made with the benefit of the trial and seeing the witnesses under cross-examination. And in this case, the judge's factual findings are important, even though they're not the main focus of the appeals. And we, for Saxon Woods, certainly do rely on a number of the judge's findings, notably concerning the conduct of Mr Costa, to support our position on these appeals. Essentially, that the judge did not correctly apply the law to those factual findings. But given that the facts are dealt with in some detail in the judgment, I'm going to try and limit the amount of time I spend on them, and obviously your lordships would have spent time reading in as well. So I'm going to avoid giving a comprehensive narrative, and instead I propose to just give a summary. But in so doing, I do propose to alight on certain particular points which are relevant to the appeals, and in particular 2 themes which run through my learned friend's written submissions in both appeals. And those themes are as follows. First, that the key steps in the exit process were approved by decisions taken by the board, either unanimously or by majority. That's one of the themes of my learned friend's submissions. And secondly, that the company's financial position was poor in 2019. And as I will seek to demonstrate, Mr Costa's case on those themes is wrong and contrary to the findings that were actually made by the judge. So turning to the background, I'll start my summary with a brief description of the parties. The company which is the subject of these proceedings, Spring Media Investments Limited, is a holding company for a group of companies which provide creative services in fashion, beauty and luxury brands. And the business operates from 3 locations, London, New York and Milan. The petitioner, Saxon Woods Investments Limited, is a shareholder in the company. At all material times, including during the trial, it held 22.33% of the shares. That said, on the 2nd of August 2024, so 4 months after the order was made, the company undertook a capital raise, issuing just under 154 billion shares at par. And that has had a catastrophic effect on the size of Saxon Woods' shareholding, which now stands at 0.004%. Now that postdates the trial, and it's not the subject of the appeals in these proceedings. So it's more by way of an update, but I will have something to say about it when it comes to prejudice in due course.
Why is it relevant?
In terms of prejudice and the relief that's granted for unfair prejudice, there is authority that one has to look ahead and make, in a sense, future-proof the relief. So as an illustration of the sort of thing that might happen if, in our case, an adequate remedy is not provided, the facts that have happened in this case illustrate the sorts of problems that might arise if you don't make a...
But the relief you're seeking is just the purchase of the shares without the floor for FLOOR.
Yes.
At the valuation that's in 2019.
Yes.
So it's whatever shares your clients have, however small a proportion of the current share capital they form, will be purchased for the determined price.
If we beat the threshold.
Yeah, you say there shouldn't be a threshold.
We say there shouldn't be a threshold,
So,
yes.
Assuming you're right, it's just a judgment.
Yeah, as I say, my lord,
So what does it matter that there's been...
It's an illustration of well, if we don't beat the threshold, we would be left as shareholders in the company.
Yeah.
And that is the sort of problem that we say relief in unfair prejudice proceedings is designed to avoid, in the sense it's designed to achieve a parting of the ways, and therefore it's a high level point, and we don't. It's not a big point, my lord. This is an update, but it does demonstrate the position that our client finds itself in now.
But if you're not entitled to be bought out because you fail on your appeal and the cross appeal is allowed, you're in the company and that's it. And you've got, if you didn't like the rights issue, you didn't participate in it. But if you think there was something independently unfairly prejudicial about the rights issue that's taken place, you can complain about that. But that's not what we're here for.
That's correct, my lord. So if we fail on our appeal, this point, well, we would have to address the potential problem arising out of the subsequent rights issue in a separate complaint.
Yep.
I absolutely accept that. The 2nd to 7th respondents are the other shareholders. They've not participated in the proceedings, but are simply nominal parties. So the only active respondent to the proceedings is Mr Costa. And he's the chairman of the board of directors. He doesn't hold any shares directly himself, but he's got a substantial indirect interest in the company. And his position, as at the date of the trial, was addressed by the judge in his judgment at paragraphs 99 to 102, and it's probably worth just looking at that. It's page 204 of the core bundle. Your Lordship should see there at the bottom of page 204, paragraph 99. And I'm looking at 99 to 102, and your Lordships can obviously cast your eyes down through those paragraphs. But to summarise, Mr Costa's interest was held through a Luxembourgish vehicles, primarily a securitisation vehicle called Green Cage. And Mr Costa was the person charged with acting on behalf of Green Cage. And Green Cage indirectly owns about 56% of the shares in the company, and for his part, Mr Costa's interest equates to around 30% of the shares in the company. But by virtue of his control of Greencage, our position at trial was that Mr Costa had de facto control of the company. Now that's the position in respect to the shareholders. So far as the board is concerned, there were no less than 11 directors of the company during the period under scrutiny, and a list of those directors is at paragraphs 4 to 5 of the petition, which if your lordships just turn on in the core bundle, you'll find at page 306. The petition actually starts at page 305. But if your lordship will see paragraph 4 sets out a list of the directors, and then further in paragraph 5, it identifies Mr Mehta was a director until the 13th of June, and Mark Loy was a director until the 18th of June 2020. Mark Loy was the appointed director of Saxon Woods, the petitioner. In terms of the witnesses, Mr Costa was obviously called, and the court also heard from Mr Loy, as I say, who was representative of Saxon Woods. And then there were 4 other directors who gave evidence. And if your lordships turn, please, to the judgment, paragraph 107 of the judgment, which is at page 207 of the file. There you have the section of the judgment dealing with the witnesses. And in terms of the directors, we have Mr Qatar, who's dealt with at paragraph 107 at the bottom of page 207. And just focusing on paragraph 108, which is over the page on 208, Mr Qatar was found to be an honest witness. However, he had little involvement in the principal matters in dispute in these proceedings. To the contrary, as he fairly accepted, his knowledge of the exit process was derived from what he was told at board meetings and conversations with Mr Costa. Next, the judge dealt with Mr Oberoi, and you'll see it paragraphs 110 and 111. Paragraph 110, it said that Mr Oberoi clearly relied on the fact that he knew and trusted Mr Costa, and that their economic interests as investors were aligned, and particularly trusted Mr Costa to give correct instructions to Jefferies. Jefferies were the investment bank that was instructed in relation to the dealings in 2019, and to ensure that the exit provisions of the SHA were complied with. Then in paragraph 111, there's some criticism of Mr Oberoi's evidence, but the end of that paragraph essentially sums up by saying he was relying upon Mr Costa's stewardship. Then we have Ms Kurtzman in paragraph 112, and again, if your lordships cast your eye down towards the bottom of that paragraph, you see the judge saying, however, here again, Ms Kurtzman had limited involvement in the principal matters under scrutiny in these proceedings. Her knowledge of the exit process was based principally on what she was told at board meetings and conversations with Mr Costa. So the important point about the evidence in respect of these directors is that it reflects what the judge had said about the investors. Essentially, most of the stakeholders in the company, both at investor level and board level, had limited knowledge of the exit process, such knowledge that they had derived from what they were told by Mr Costa, and they relied upon Mr Costa to conduct the exit process, including by giving correct instructions to Jefferies. Now, that's important because, as going to one of the themes I mentioned at the outset, Mr Costa does seek to rely upon the notion that the steps in the exit process were approved by the board. But we can see from these parts of the judgment that the board actually had limited involvement in the process and what was actually going on, and that they were relying on Mr Costa. The judge then considered Mr Oberoi, and this is a slightly unusual situation. We have a Mr Oberoi and a Mr Oberoi, which is unusual. But Mr Oberoi and Mr Costa, these were the 2 directors who were, to varying extents, actually involved in the conduct of the exit process. And whilst we're in this section of judgment, it's just worth looking at what the judge said about the quality of their evidence. So paragraph 114, we see the judge commenting on Mr Uberoy's cooperation with the court. He says there's an issue with that, and that concerned disclosure failures. And then paragraph 115 to 116, Mr Uberoy made it clear in his witness statement that he was not particularly concerned with the terms of the SHA. His explanation of clause 6.2 was that, in my experience, these clauses are usually designed to trigger a discussion around the date specified in the agreement, and then people work in good faith to figure out what should happen next. If it doesn't make sense at that point in time, you don't sell. And then just going on, it said, at no point does Mr Uberoy suggest he considered whether this strategy was in line with the terms of the SHA. In particular, he does not seem to have even asked himself whether the other parties to the SHA, in particular Mr Loy and Mr Flamini, might have legitimate concerns that it was not being complied with. And the Lordships can have a quick look at paragraph 116 as well. So, as you can see, the judge was not impressed by the quality of Mr Uberoy's evidence regarding the approach to the Shareholders Agreement. As for Mr Costa, the judge dealt with his evidence at paragraphs 118, 117 on to 120. I will come back to those paragraphs, but the upshot, or punchline if you like, is at paragraph 120. And there you see that the judge did have criticisms of the reliability of Mr Costa's evidence, in the sense that Mr Costa was reliable as regards matters which were documented, but the judge felt he couldn't place any great evidential weight on his accounts of undocumented conversations. So that's a quick review of the key parties and what the judge made of them. Turning then to the chronology, in fact, the narrative of the case starts earlier in the judgment at paragraph 14. The Lordships could just go back to it's, page 173 of the file. And again, I'm not going to take you through this line by line, obviously. Your Lordships can cast your eyes through it. In short, the business was founded in 1996 by Mr Loy. It was originally operated through a different company, Spring Studios Limited, which is now a subsidiary of the company, Spring Media. By 1998, the other two individuals that had founded the business with Mr Loy had left, leaving Mr Loy on his own as the sole driving force. SSL grew rapidly, and Mr Loy hit upon the idea of expanding into New York. And to that end, he sought external investment, and it's at that point that Mr Costa became involved. It's very much a commercial relationship, and this is reflected in the fact they entered into a shareholders agreement, and that's referred to at the end of paragraph 19. And remember, we're here in 2013, so this is the first shareholders agreement. The subject of this appeal is the second shareholders agreement. But it's worth just quickly looking at the first agreement. It's in the consolidated core bundle at page 27.
You mean the supplementary?
Consolidated supplementary bundle. So it's behind tab 2 in the hard version. It's page 27 of that. And if your Lordships have that, you see that the agreement's dated 27th of February 2013.
So is this the core supplemental or the supplemental?
Forgive me, it's the supplemental.
I think there are extracts in the core supplemental.
I think that's right, to keep it to the page limit.
Do you happen to know whether you're going to be going outside the hard copy core supplemental?
Only on a handful of occasions, but I am probably going to go to it a few times. But it's mostly, we are predominantly in the core bundle.
Okay.
Sorry, I can't be of more assistance on that front at this stage. So this is the first of the shareholders' agreements, and if you turn to page 30 of the bundle, you can see the first paragraph deals with the parties, and you can see reference there to the company, namely Spring Studios Limited, someone called Mary Loy, who should be Mark Loy, and then an entity called the Investing Shareholders. And if your lordships read down, that is treated as including, amongst others, Mr Costa and Greencage. And for present purposes, this was the agreement that governed the arrangement pursuant to which the investing shareholders provided this further investment into the business. And we don't need to review it in detail, but I just want to take you to clause 4.3, which is on page 45. And if your lordships look at clause 4.3, you'll immediately recognise that it's in exactly the same terms as clause 6.2, which is the subject of the current appeal, except for one important point, which is that the investment period in this agreement is the 30th of June 2018. You see that in the second line of 4.3. So in the later shareholders agreement, that was extended to the 31st of December 2019. So there have been two deadlines, in fact, for an exit. And we say that's significant. These dates were the subject of specific negotiation. And when it proved not possible to reach the 30th of June 2018 as part of the later agreement, they extended the period to the end of 2019. And regarding the significance of the exit process, Mr Lloyd gave evidence on that front, and we see that from the judgment. Your lordships could go back to the core bundle, page 175, at paragraph 20 of the judgment. Lordships will see there that the judge held as follows. Mr Lloyd's evidence is that this, he refers to the 2013 SHA and the exit, and he says Mr Lloyd's evidence is that this provision was critical to his entry into the agreement, and that he would not have entered into it had it not been there. His explanation for this was that the objective of the US expansion was to increase the value of the business in order to facilitate his own exit. So what happened next was, over the next few years, there was further financial and corporate restructuring. One important point is that in 2014, Mr Lloyd transferred his shares from his personal name to the petitioner, Saxon Woods, which is the nominee of the Logan 2011 Capital Trust. Mr Lloyd remained a director of the business as Saxon Woods' nominee. The next significant milestone was the round of financing in 2016, and it was that was the catalyst for the entry into the 2016 Shareholders Agreement, which is the key agreement in these proceedings. And the background to that is described in paragraph 24 of the judgment, still on page 175 of the bundle. And your lordships can look at paragraph 24 and down to 25 as well. What your lordships will see is that at this stage, the company, for the purposes of these proceedings, namely Spring Media Investments Limited, was incorporated and brought in as a new topco. So it was around the 2016 restructuring that we have the introduction of the company for present purposes. The second point is, pursuant to the restructuring, Saxon Woods ceased to be the majority owner of the company. Ended up owning a stake of around 22%. Third point is what I referred to previously, which is that under the new arrangements, the expiry of the investment period was extended to the 31st of December 2019. And just to show you lordships that, you see the the 2016 agreement is behind tab 18 at page 508 of the core bundle. And we'll be going back to it, but for your reference now, the clause 6.2 is at page 533. And your lordships will see it's in exactly the same terms as the terms of the 2013 clause 4.3, except for the changed date. So as I said before, in the context of the 2016 financing, the investors specifically turned their minds to the length of the investment period and extending the time for the intended exit. Two other events around this time. First, Spring Place was established. Your lordships will see that in paragraph 25 of the judgment on page 176 of the bundle. That's a members club based in the same premises as Spring Studios in New York. It was owned by Mr Costa and a number of other investors, but Mr Loy was never involved, and references to Spring Place do crop up in the narrative. Secondly, Mr Loy stepped down as CEO of the company at the end of 2016. And then subsequently, if we see paragraph 28 of the judgment, and consistently with what we saw before about Mr Loy's intention to seek an exit once the New York venture was up and running, we see that in paragraph 28, Mr Loy commenced negotiations with Mr Costa to sell his shares to him. And indeed, a price was agreed valuing the company, this is November 2017, valuing the company at around $120 million. But Mr Costa, as we see at the bottom of paragraph 28, then resigned from the proposal in early 2018 and no sale took place. That's all basically background. The key narrative for our purposes on these appeals is the exit process and what happened or was supposed to happen with that process. And the judge's chronology of that starts at paragraph 34. And the judge took it as his starting point, a board meeting which took place in November 2018.
That's 5 years after the first agreement that there would be an exit by 3 months earlier than that. Nothing seems to have happened in relation to an exit after 2013 for some years. Is that right?
Clearly the company required further financing in order to, and that probably interfered with the exit process, and it needed further financing, and that led to the 2016 restructuring. Plainly, it was recognised that an exit could not be achieved at that point, hence the extended date to the end of 2019. The first reference in the judgment, at least, to negotiations for an exit takes place in 2017, directly between Mr Loy and Mr Costa.
So that's a share sale, isn't it?
Yes.
So that's
yes, that would be an exit just for Mr Loy.
Yes. So in fact, as you say, the starting point of the chronology for the exit process is November 2018.
Yes.
And there's no findings about what was or wasn't done or what failures existed before that date in relation to the process of it.
There was, in the trial, there was evidence regarding what had happened prior to 2016. The judge, though, naturally was focused on the exit process under the Shareholders Agreement for present purposes, namely the 2016 agreement. So he did start his narrative after the 2016 agreement.
So is it right that the conduct complained of is from November 2018 onwards? No complaint is made of Mr Costa's conduct prior to that?
That's right. Yes. For the purpose of this appeal, certainly, there's no complaint about anything in respect to the exit process prior to November 2018. At the trial, there was some consideration given to his conduct prior to that. There was the general thrust of it was that Mr Costa was interested in other types of arrangement, the Spring Place type arrangement, bringing in a broader spring concept. So there was documents concerning a spring master plan, for example, which had the idea of a broader brand, let's say, involving the New York, Milan and London Spring Studios businesses, but also the Spring Place Club under a broader umbrella. Notions like that were abroad, as it were being talked about prior to November 2018. And at the trial, I can't remember precisely, but we would have been characterising that kind of behaviour as not compatible with a genuine desire to seek an exit. But there's no doubt, my lord, because those kinds of arrangements would not have comprised the sale outright of the company. So certainly, in respect of the more historic conduct, we did rely upon it as illustrative of a mindset, at least on the part of Mr Costa, that was not compatible with seeking an exit. And there was some evidence, as I say, about what he was actually doing or thinking about. But the actual complaints in terms of unfair prejudice concern the exit process only under the 2016 agreement and only from about November 2018.
And you may have made those complaints, but no finding was made in relation to that, or in relation to the extent to which Mr Loy had agreed with that, or the board had agreed with that. There's no findings at all about the situation before November 18, is that right?
That is right, yes. So here we are in 2018, November, that's paragraph 36. And, my lords, you've obviously had a look at the chronology for yourselves, but there are four areas I do wish to draw out for the purposes of this introductory presentation, and they're as follows. Firstly, the level of board engagement in the exit process. Secondly, Mr Costa's treatment of prospective purchasers. Thirdly, the steps which Mr Costa actually took, or more accurately failed to take, to pursue an exit. And fourthly, the financial position of the company. So there are four aspects of the chronology which I will just dwell upon. Firstly, dealing with the level of board engagement in the exit process. As I said, the starting point is the board meeting on the 20th, starting point for present purposes is the board meeting on the 20th of November 2018, and we see that dealt with in paragraphs 36 to 38 of the judgment. Now, at that meeting, the board approved the appointment of Jefferies as its investment bank, and we see that in paragraph 38 towards the bottom. And it was also resolved that the company's relationship with Jefferies would be led by Mr Costa. So Costa would be leading the exit process and leading the dealings with Jefferies. It was also, though, resolved that there should be an exit subcommittee appointed. And again, we see that right at the bottom of paragraph 38. And that committee was appointed comprising Mr Aspinall, Mr Oberoi, Mr Uberoi and Mr Loy. Now, notwithstanding the fact that Mr Loy was on the exit committee, Mr Costa actually refused to involve Mr Loy in the exit process. And just as an example of this, if your lordships have a look at paragraph 43 of the judgment, you can see that by early 2019, Mr Loy's emailing Mr Aspinall, referencing what he considers to be Mr Costa indulging in a delay tactic regarding the sale of Spring. Mr Loy therefore tried to organise a meeting of the exit committee, but that didn't happen. Separately, Mr Mehta, another one of the directors, who was also keen to realise his investment, asked Mr Costa to arrange for Jefferies to come and give the board an update on the sale process, which you might have thought was a perfectly reasonable suggestion, but Mr Costa refused on the basis that he did not want to sit Jeffreys in front of Mark Loy and Maurizio Flamini. So that's a clear example of Mr Costa excluding his co-directors, and specifically Mr Loy, from the exit process. And it's worth noting in this context that there was only actually ever one meeting of the exit committee, and that took place on the 26th of March 2019, at which Mr Costa promised to share information but actually failed to do so. And that's referred to at paragraph 47. Another example of Mr Costa's treatment of Mr Loy specifically is at paragraph 49. And you see their reference to negotiating the Jeffreys engagement letter, which seemed to have taken a long time. Finally, a draft of the engagement letter was circulated on the 10th of April. Mr Loy looked at it and it confirmed his worst fears. And you see there an extract from the letter, from the engagement letter. And then Mr Loy in paragraph 50 sent an email suggesting the letter be redrafted to constitute only a mandate to assist with the sale of the entire group. Because if you look at the extract there, it's a much broader retainer. But Mr Costa, as we see from paragraph 50, responded badly to that suggestion. And Mr Costa's particular concern seems to have been a suggestion by Mr Loy that Mr Loy communicate directly with Jeffreys. A suggestion to which Mr Costa responded, unless authorised to do so by the board, you should take no steps to negotiate or communicate with Jeffreys. Any unilateral steps taken by you without the appropriate authorisation will not be tolerated and will be treated with the utmost seriousness. So, unsurprisingly, this response seems to have confirmed to Mr Loy the idea that what Mr Costa was discussing with Jeffreys was something other than a sale of the company. And it's important to note that Mr Loy was not the only director who was denied information about the exit process. Another director who was pushing for information was Mr Flamini, and the judgment gives an example of how he was treated in paragraph 55. You see there a reference, page 189 of the bundle. On the 2nd of July, Mr Flamini sent an email to Mr Costa pointing out that he was yet to share the mandate letter with Jeffreys or to provide any substantive information as to the process. Mr Costa then replies on the 8th. Both letters can be described as intemperate. However, one element of Mr Costa's reply is notable. In response to Mr Flamini's criticism of the lack of progress on the deal, he said, and then Lordships can read what he says, and the judge comments, the references in this document to what the board had been told and what it had agreed seem to me to be simply incorrect, or at least to run contrary to the records of the board's deliberations. However, the key point is that it is clear that in Mr Costa's mind there were now a significant set of preconditions to the commencement of any marketing process, some of which would take some time to satisfy. So, as I say, you see what Mr Costa said to Mr Flamini, and he said to pursue the exit, the board agreed that the company should improve its results, complete a vendor due diligence process, hire a talented CEO responsible to prepare a business plan. This is the key factor to pursue the exit process. The fact is, that hadn't been agreed by the board, as the judge found. So Mr Costa was not only refusing to provide updates, he was misrepresenting what the board had been told and what had actually been decided.
Is that at a meeting that Mr Flamini had actually been present?
Mr Flamini was at the meetings, yes.
So, on the face of it, what Mr Costa is purporting to remind Mr Flamini of something which Mr Flamini presumably would have known was not the case?
Yes. So Mr Costa prepared just to brazenly tell his fellow director things that surely, on reflection, he must have known that Mr Flamini would have recognised were not correct. But that we say is illustrative of a generally hostile and overbearing attitude that was being displayed by Mr Costa towards his fellow directors. And obviously not conducive to any kind of cooperative approach around the exit process.
Is that a I mean, I haven't tracked this through because I don't know the document to which that is referring. Is there a document? Because it's curious that there's an opening of inverted commas in the middle of the second paragraph, as if it's a quote from something, but they never close.
I think they close at the bottom.
Well, no, they don't. That's the quotation that closes. There's a separate.
Yes, you're right. Well, my lord, we can look into that. It may just be again for effect by Mr Costa.
But the judge seems to say that this seems to run contrary to the record of the board's deliberations. So presumably there's a document he's referring to.
Yes, there are board minutes, and
but he doesn't. One of the issues of the judgment is that I couldn't actually track what lay underneath some of these findings.
My lord, well, I can tell you, lordship, that there was a meeting, I think, on the 2nd of June, and there are board minutes of that meeting, and certainly what is said at that board meeting is that the exit process was running.
But you see, the reason I was, and I apologise if I'm going down a rabbit hole, but I think one of the themes that's going to be developed, presumably, is that you are beginning to develop, is that Mr Costa is either misleading or not being full and frank with the board. And
yes.
So this is the first illustration I think we've encountered, and I was just trying to understand what underpins what the judge is saying here in paragraph 56.
Yes.
At the moment, I can't fasten on anything.
So, my lord, this particular communication, I would suggest, is a strong illustration of a browbeating type of approach.
You may be right, but on the face of it, because you're saying he's reminding. The judge is saying he's reminding Mr Flamini of something which wasn't in fact the case, and sort of browbeating him into accepting a different version of events than had in fact occurred.
Yes.
I think that's what you mean by browbeating.
And refusing to actually give any information as to what's going on.
And all I was really asking is there some document that underpins that finding by the judge, the records of the board's deliberations, especially given the curiosity of those little inverted commas that suddenly appear and then don't?
Well, my lord, yes. What we have is the board minutes from the 2nd of June meeting, and I beg your pardon, 20th of June. Those are in the supplemental bundle, not the core supplemental bundle, the supplemental bundle at tab 13, page 76. Well, the particular reference I would refer you to is at page 76, item 5 on the agenda, which simply says update on the exit procedure. FC informed that the mandate with Jeffreys had been executed on June the 18th and the project is running. So that's what's being said at the board on the 20th of June.
Sorry, it's page 76 of the
CSB.
Core. It's the other one, it's the core.
So this is now the core supplemental.
I'm sorry, yes, the core supplemental.
Sorry, because I don't have that electronically for some reason. That's just maybe my electronic filing doesn't have it. Maybe.
Yes, it's the core supplemental bundle. Those are the minutes of the 20th of the June meeting. Right, well, let's stay in this one for time being. And at page 76, you see 5, update on the exit procedure. FC informed that the mandate with Jeffreys has been executed on June the 18th and the project is running. Now,
I have that at page 320 of the supplementary bundle.
yes, I think it's also there, my lord.
Yes, which I think we do have, because I don't have any page 75 with it, but I do have the document.
And then there's the meeting in February, which is page 220. Of the supplementary bundle. So you see there the minutes of the meeting on the 28th of February. That I think is the only other meeting. So we have the meeting in November 2018. Then we have the meeting on the 28th of February 2019, which is at page 220. And there is, in that document, there is also reference to the exit process at item 4, which is page 222. And it's mostly focused on the appointment of Jeffreys. I will be coming back to this document. And then I've given you the reference to the June meeting. And I would suggest that there is basis for the judge's finding that what Mr Costa was telling Mr Flamini in this email that we've been looking at is not supported by any resolution or discussion at least recorded in the minutes of either of those meetings.
Well, there's something in the February minutes, at least, that's consistent with it, isn't it? For example, the line, second paragraph on page 44 of the CSP, where it is in the other ones I don't know, where it says, for AO to get the best investors, you need 1, consistency in financials, 2, a great CEO.
My Lord, forgive me, which meeting?
So
the February meeting?
February meeting. So I'm at page 44 of the core supplementary.
223 of the
Thank you.
longer one. Just the second paragraph down.
Certainly, my Lord, there is reference to the desirability of getting in a good CEO and getting good financials, but they're not put as a condition of a sale. And the thrust of the discussions in February, as one can get from these minutes, is that the company is ready for the new CEO and for the exit process to proceed.
Well, the bold resolution is to circulate Jeffreys' engagement letter pursuant to which Jeffreys will commence the exit process as soon as the new CEO is identified.
Yes. Now, and the other one. I should say, I am proposing to deal with this meeting in more detail in due course. What we say at this meeting is that, of course, there was consideration given to the need to bring in a CEO, the need to pause the exit process until that happened, but there was no sense that that would be a significant period of time or any actual impediment to completing the exit process by the end of the year. And I will develop those points in more detail. And in that sense, what Mr Costa is saying in this email is not in keeping, at least, with the tone of the discussions. Because what Mr Costa is saying here is you can't have a sale, and indeed it's been agreed that we can't have a sale, until various things have happened. And that did not reflect the discussions at the meeting. The meeting, while certainly mindful of the need to bring in a CEO and of the importance of having a good CEO, certainly did not agree that was a condition of a sale. Reason being that the context of the discussion in February 2019 was that none of this would be a problem. The exit could readily be achieved by the end of 2019. So what's happening is here with this email is we see Mr Costa embellishing certain aspects of the discussion and very much hardening their impact in terms of the likelihood of achieving a sale. But the broad point is it's browbeating, as I said. He's not actually giving information regarding what's going on. This is July, beginning of July. This is several months on, and Mr Flamini is asking what's going on.
I mean, I'm just looking for what the judge might have been talking about, but at the bottom of page 222, the first paragraph under exit process update suggests, is this right, that all we need to do is for today's board meeting to approve the budget and the Q1 numbers. After that, they can market the companies.
Yes.
And you're saying that's different. That's from the second paragraph of this 8th of July email.
Yes, it's the second of 8th of July. Forgive me, my lord. Yes, my lordship makes the point better than I did.
Well, I'm not trying to make a point. I think you are making points, but I'm just trying to tie together the.
That was the point I was seeking.
I'm just trying to identify what it is that the judge was saying in that first sentence of paragraph 56, or in paragraph 56, that he seems to have thought was simply incorrect or contrary to the record of the board's deliberations.
Yes, so it's worth, again, anchoring ourselves in the chronology. This is the 8th of July. That's obviously several months on from the February meeting. And there's been one meeting since then on the 20th of June. And the report in the 20th of June meeting was that the exit process was running. That was the report. That's the only comment in those minutes about what was going on with the exit process. Right. True, several months prior, there was this meeting in February. But as your lordships pointed out, there were aspects, at least, of that discussion as well that showed a generally positive disposition towards getting on with marketing the company and proceeding with the exit process, albeit recognising the need to bring in a CEO. But we have then, in this email, Mr Costa basically saying that it had been agreed that various things must happen before the exit can be proceeded with. So certainly, in my submission, the judge was entitled to find that that is incompatible with actually a fair reading of where the board had got to at these two meetings, and was a much more rigid and demanding set of requirements than had been put to or indeed ever agreed to by the board. And what it reflects is, as the judge goes on to say, that certainly from Mr Costa's point of view, he didn't consider a sale could or should happen before these various things took place. And he had gone ahead of where the board had got to in that regard. So that was Mr Costa's treatment of Mr Flamini. There was also Mr Aspinall, who was seeking information about the exit process, and he was a member of the exit committee. And the judgment records how he was treated in paragraph 60, page 191. So it says, Mr Aspinall, another director who also wished to sell his shares in the company, was seeking information from Mr Costa as to the progress of the sale. Mr Costa declined to provide any such information. Again, that's a startling finding. Mr Aspinall's on the exit committee. Why would Mr Costa want to be secretive about what's going on with the exit process? And he goes on to say, on the somewhat surprising ground that I have nothing to show or demonstrate to anyone. And the judge goes on, at this point it is clear that in Mr Costa's mind, the conduct of any process for the sale of the company was a matter for him and him alone, and he saw no reason to discuss it with any other board member.
Do we have any cross-references to evidence or materials in relation to 60?
Yes, Mr. Aspinall's. That is email correspondence. The judge doesn't specifically reference it there. And that is a. Yeah, I mean, certainly I have nothing to show or demonstrate to anyone as a direct quotation from the email.
I was just asking for a reference. Sorry.
We don't, the judge doesn't refer to the email.
Do you have the reference?
It's not in these files. It was certainly in the obviously the trial bundle.
So, in the 5 volumes of supplemental materials, that isn't actually there.
No, because it's not specifically referred to in a skeleton argument.
Okay.
Pardon? And there isn't any dispute about that, my lord.
No,
That was certainly something that was said. So then we get to the judge's overall conclusion on Mr. Costa's treatment of the board, and that's really captured some way on in the judgment at paragraph 163, so page 228. One of the things which appears clearly from this recital of the facts is that Mr. Costa, at all times during the disposal process, seems to have taken the view that, as regards the disposal process, he was the company. His primary focus at all times appears to have been to ensure that no director or shareholder, other than Mr. Uberoy, had any knowledge of or involvement in the exit process. It is fair to note this appears to have been largely unchallenged by most of the other directors. But when Mr. Aspinall and Mr. Lloyd tried to acquire any information as to the conduct of the process, they were aggressively rebuffed. The core issue seems to have been that the other directors were satisfied with Mr. Costa's assurances that he was doing everything in accordance with the advice of Jeffreys. And their advice seems to have been that acting on high quality advice, and their view seems to have been that acting on high quality advice must necessarily have been the best thing for the company. So that sums up the judge's view as to what the other directors, their attitude towards Mr. Costa, and indeed Mr. Costa's attitude to the directors in general. And then we get to the judge's conclusions at paragraph 200 to 202. So focusing on the Mr. Costa's conduct of the exit process. In 200, we see the judge's finding that the company breached its obligations under the Shareholders Agreement. And the reason being that it entrusted the conduct of the sale process exclusively to Mr. Costa. Mr. Costa did not conduct that process in accordance with the obligations of the company. And then your lordships can read on, reference to Mr. Lloyd complaining. And then towards the bottom, as a result of all this, Mr. Costa pursued on behalf of the company a strategy which he knew or should have known was contrary to the obligations of the company, and in particular to the commitments to Mr. Lloyd. And then 201, one of the more important planks of Mr. Costa's defence is his argument that it was the board and not him alone who made the decisions in relation to the sale. And then he says that requires some analysis, and the analysis is in paragraph 202, and I invite your lordships to read paragraph 202. Just picking up a few points. Towards the bottom of the page, no board member other than Mr. Uberoy seems to have had any idea what it was that Jeffreys had actually been instructed to do. Mr. Costa's determination to maintain control of the sale process was so strong that he responded with threats to suggestions from other directors that they might even speak to Jeffreys. And then reading down towards the middle of the page, I'm in no doubt that Jeffreys were clearly aware of Mr. Costa's desire to maximise the profit on his shareholding, and so it was perfectly reasonable for them to advise that this might be best achieved by waiting until late 2022. Mr. Costa and Mr. Uberoy were therefore the only people in a position to know both about the scope of Jeffreys' mandate and about the company's obligations under section 6.2. and therefore to realise that what Jeffreys were engaged in was absolutely not working in good faith towards an exit by no later than 31st December 2019. And that was because Mr Costa had not instructed them to do that. In giving their fellow directors a different impression, they misled the board. Mr Costa therefore cannot rely on the argument that it was the board who had caused the company to breach its obligations, since the board's decisions in the matter were the result of the fact that he had misled it. And the reason that this is important, as I observed before, is that Mr Costa is seeking to resuscitate on these appeals the idea that every step in the exit process was approved by the board of directors. But that's not an argument that's open to him anymore in the light of this very clear finding.
Is that a reference to the two meetings that we've seen the minutes of?
My Lord...
February and June, isn't it?
In terms of misleading?
Yes.
Yes.
So is the finding that they misled the board at those meetings?
Yes, I think it must be. And more generally, that's certainly true. So, for example, I've referred already to the 20th of June meeting, it being said that the exit process was running, when in fact it wasn't, because the board was under the impression that Jeffreys were being told that Jeffreys were running the exit process, when in fact Mr Costa had not instructed them to achieve an exit in accordance with clause 6.2. So certainly that was misleading. Again, the judge isn't particularly specific here. I suspect his comment about misleading the board, or I would suggest, encapsulates some of the other communications,
yes,
a couple of which I've referred your lordships to.
That's misleading individual members of the board,
yes,
and thereby
the board more generally. I mean, generally speaking, giving the impression that Jeffreys are handling matters, handling the exit process, above all in board meetings, but also in any other communications. And so, insofar as on this appeal, these appeals, Mr Costa still seeks to argue that, well, everything was done in accordance with board approval. That's not open to him, because that, as far as the board did anything, it was contaminated by them being under the impression, as a result of what Mr Costa was telling them, that Jeffreys were on the case, as it were.
Why do you say the question of whether the board was being misled is relevant to what we have to decide? What place does it take in the jigsaw puzzle?
It takes specifically in relation to the breach of 172. So we appeal against the judge's decision that there was no breach of section 172 by Mr
Yes,
Costa.
I know you do, but why do you say that put that piece of the jigsaw into the broader context? What relevance does it have to the overall appeal and cross appeal? Why is it relevant?
Well, the judge decided there was no breach of section 172. We said there was, and we relied quite heavily in that regard on 172.
I get that. Why are you doing it?
Because that's unfairness, that's freestanding of clause 6.2.
Right. So you say if the judge was wrong to hold no breach of fiduciary duty and there was a breach of fiduciary duty independently of clause 6.2, that would justify a buyout order without restriction.
Yes. That's a freestanding basis of unfair prejudice. So if we're wrong on the construction of clause 6.2 and some looser, I think the way it was put, some looser obligation should have been the interpretation, and then we're also wrong as to whether that was breached. So my own friend wins on construction and he wins on breach. We've got another leg to stand on, third leg if you like, which is that there's a breach of 172. That requires us to win our appeal on 172.
And if you do, if that was the scenario that unfolded here, are you saying that this court should exercise the discretion to make a buyout order afresh?
Yes.
Rather than remitting it to the judge?
Yes, because there's the basis upon which we argue prejudice substantially overlaps both a claim based on a breach of clause 6.2 and a claim based on a breach of 172 and 174. And the prejudice is much the same. The prejudice is that they didn't take the opportunity for an exit.
But can I just put a card on the table just in terms of a thought so you can think about how to address it? If there's a breach of clause 6.2 without a breach of fiduciary duty, that gives rise on the face of it to a loss of your client losing the opportunity to participate in a collective sale.
Under clause 6.2?
Yeah.
Yes.
But that would have required the consent of the other shareholders for such a sale.
We dispute. That's not. There's quite a big conversation to be had around the extent to which other shareholders could consent.
Okay.
Their consent was required.
Right. And that might or might not inform whether there should be, even if there was a breach of clause 6.2, a buyout order, and if so, at what price?
Can you forgive me, my lord? What might inform?
Assume there's just a breach of clause 6.2, but without any accompanying breaches of fiduciary.
Which is what the judge found.
Which is what he found.
Yes.
As I understand it, one of the arguments is that shouldn't, of itself, give rise to an automatic buyout. In other words, your client could be, in effect, compensated under Section 994 for whatever the loss of the opportunity to sell his shares might have brought him, and the judge took the view that if it was less than, the offer would have been less than 75 million, the other shareholders wouldn't have agreed to sell anyway. So in a sense, he's lost nothing.
Yes.
Consequential on the breach of clause 6.2.
That's the judge's analysis. Yes.
I know you have issues with that.
Yeah.
But as I understand it, your argument based upon what you're showing us now, this misleading the other directors, misleading the board, if you like, short circuits that whole area of debate. Because you just say whatever that led to, your client shouldn't be allowed to, or shouldn't be required to stay as a minority investor in a company managed, controlled, run by somebody who engages in this sort of behaviour.
Yes. It makes it a simpler case in a sense.
And that was an argument put to the judge.
Yes.
But which he didn't have to deal because he found there was no breach of fiduciary duty.
Yes.
So that's how this question of breach of fiduciary duty fits in the overall jigsaw.
Yes, it's in fact a shorter, more simply stated case of unfair prejudice.
Because the reason I put it to you, the reason I was picking it up is because you said something to me much earlier this morning, that the whole purpose of Section 994 is to achieve a parting of the ways. Sorry, that's not the exact words you used, but that was pretty much what you said. It'll be on the transcript. And I will just question that is not what Section 994 is invariably designed to achieve. It is appropriate to have such a parting of the ways in certain cases. For example, if there is a quasi-partnership and there's a breakdown of relationships because of misconduct, that's not this case because this is not a quasi-partnership. I think everybody accepts that. This is a straightforward commercial relationship. So we're not into that. We're not into the equitable considerations that Lord Hoffman spoke about in O'Neill and Phillips.
I agree with that, my lord.
Right. Okay. I just wanted to mark it down because.
But perhaps I wasn't proposing to make it such a sweeping statement. My point was certainly in some cases, a parting ways is absolutely the correct answer. And the reason it's the correct answer is to prevent the prospect of further disputes arising down the road. And the parting, and in a sense, there is authority, which I'll come to, that does talk about the desirability of future-proofing, for want of a better phrase, the relief, as opposed to simply focusing on remedying the most immediately proximate wrongdoing. 994 is a broader jurisdiction which gives the court the ability to actually think hard about what is the best way to, in fairness and equity, to resolve these disputes, not just this dispute in general. And obviously in a quasi-partnership exclusion case, parting ways makes perfect sense, but I would suggest that that sort of philosophy goes further. It's engaged where there's every prospect of further prejudice happening down the line, And so not necessarily in a quasi-partnership context. And certainly in this case, where you had, if you had a finding of breach of 172, that is to say, director prepared to act otherwise than in good faith, and in this case particularly against the interests of a minority shareholder, you have a situation where you've got a shareholders agreement which did provide for an exit, which is now ancient history and has not happened, and there's no reason to think it will ever happen. That is a situation where we would say it's appropriate for the court to take a longer view as to what relief should be granted. So yes, we do say that in this case, a parting of the ways absolutely would be the appropriate course of action. And indeed, if we are right that there was a breach of 172, that puts us squarely in the territory of unfairness, which would allow us to get an order of that kind.
But then some precision in identifying what underlies the judge's observations at the end of paragraph 202 becomes quite important.
On misleading the board. Yes. Well, my Lord, I see that. I will come back to, obviously I'm going to deal with 172 in more detail, and hopefully I'll be able to go back to that particular point.
Mr. Davis, you told us that
I know.
we need to have a break for the transcribers, and I think you told us when we should have it.
And I'm late.
So shall we take our 10 minutes now?
Thank you, my Lord.
Thank you very much.
All right.
They've given up. So it's actually specifically referred to. Yeah, we can do this as well.
Court, rise and table.
Yes, Mr.
Thank you, my
Davis.
Lord. So, my Lord, I was working on the exit process and how it was dealt with in the judgment, focusing on initially the level of board engagement and referred to the way in which Mr Costa treated his fellow directors. I'm now going to move on to his treatment of prospective purchasers. And the main party which expressed an interest in the company during this period was a fund called Metric, which Mr Loy introduced. And Metric first made contact with Jeffreys in August 2019. And the judge recorded what happened when they did at paragraphs 57 to 58 of his judgment, which is in the bundle at page 189.
Sorry, just to give me that.
Yes, it's paragraphs 57 to 58 of the judgment, page 189 of the core bundle. And so you see that at the bottom of the page, Mr. Loy was looking for investors and he found Metric, and he discussed with Mr. Balfour of Metric, and an evaluation of $100 million was arrived at. And then on the 8th of August, the fact that Metric wished to make an offer was communicated to Mr. Minyard of Jefferies. Mr. Minyard had initially played for time, suggesting they get in contact in September, but Mr. Balfour replied, explaining that Metric would be keen to move forward ahead of September. Mr. Minyard forwarded this to Costa, who responded, ridiculous. I would tell them that there are many parties interested and there will be a competitive bid. Mr. Minyard responded, and we're not ready, new CEO, etc. I will call him. The judge then said, this is a slightly troubling exchange, and that Mr. Costa's observation to Mr. Minyard was, to both of their knowledges, untrue. Now, that observation must be a reference to the idea that there were many parties interested. However, it is notable that Mr. Minyard seems to sought to construct a better and more truthful reason for delay. And then, further on in 59, the parties speak on the 16th of August. Interestingly, Mr. Balfour seems to have asked Mr. Minyard that's Mr. Minyard of Jefferies, what his mandate was. And Mr. Minyard responded that his mandate was open. That is, he was instructed to secure interest generally rather than to affect any particular transaction. It says there are good commercial reasons why Mr. Minyard might have given that response. However, what he certainly did say, as Mr. Balfour recorded in an email to Mr. Loy, was that Jefferies were not prepared to entertain any offer at this stage. As Mr. Balfour said in the same email, it's a bit bizarre to hear from an advisor that preparing an offer would not be a good use of time. So you can see an element of brush off, to say the least, being given to Metric when they first come along, and that's consistent with the fact that Jefferies, as was the case, were not actually instructed to pursue a sale by the end of the year. Metric then made an offer for the company, or an expression of interest, in September 2019, which valued the company at $110 million. And you see that in paragraph 61. So halfway down that paragraph, submitted on 13th of September, a formal non-binding expression of interest valuing the company at $110 million. And then again, somewhat surprisingly, Jefferies does not seem to have responded to this. So Mr. Loy tried to get the other directors and shareholders involved in the discussions with Metric, and we see that in paragraph 62. But Mr. Costa prevented that happening. So Mr. Loy tried to coordinate a meeting between the other investors and Metric, but Mr. Costa prevented that happening. You can see he cancelled the meeting. And then towards the bottom of the paragraph, it is noticeable here that what Mr. Costa seemed most focused on in his response is the preservation of his own exclusive role as negotiator and conductor of the sale process. Now, Metric was not the only interested party who Mr. Costa...
Just for reference, that's obviously a reference to a series of emails, or an email at very least. Is that anywhere for us to find?
Well, what we're going to do is look at our written closing submissions, which are pretty lengthy and detailed, and try and identify some of the specific documents that are the reference points for these findings that your Lordship has referred to. And we'll try and give you some more accurate answers as to the particular documents that found these findings. Of course, the findings are not appealed, but I entirely appreciate your Lordship's desire for more foundation for it.
That's right. It's just at the moment I don't know exactly what the extent to which some of the findings may become controversial, given that there's debate over the question of breach of fiduciary duty.
I understand. Thank you, my Lord. So, as I said, it wasn't just Metric. There was also the Hutt Group, who also received treatment which is not compatible, we say, with any effort being made actually to try and sell the company. And the judgment deals with them at paragraph 70, 71. And it's in the context of the approach from the Hutt Group that we have a rather telling email from Mr Costa, and we see that in paragraph 70. So Mr Costa learns through Mr Rami that the Hutt Group are potentially interested. Mr Costa replies. First paragraph you see of his reply is an attack on Mr Loy. And then it's really the second bit. I have no intention to speak or engage any conversation with whoever is in touch with him. So Mr Costa blankly refusing to deal with any bidder that he considered was in any way associated with Mr Loy. And that kind of conduct continued into 2020. As late as February 2020, neither Metric nor the Hutt Group were being given access to a data room, for example, even though there was a data room set up. And for your Lordship's reference, that's paragraphs 91 to 94 of the judgment, over on page 202 of the file. So whatever construction one adopts of clause 6.2, we said, and the judge agreed, that this treatment of prospective purchasers was plainly in breach of the company's obligations to give good faith consideration to any opportunities for an exit. And that's what the judge held at paragraph 198 of his judgment, where he found that that aspect of clause 6.2 had been breached. So that's looking at the treatment of prospective purchasers, obviously very briefly. Then I turn to the steps which Mr Costa actually took, or rather failed to take, to pursue an exit. The answer is he wasn't taking any proper steps to pursue an exit at all. In fact, he was delaying it deliberately because it served his personal interest to delay it, even though a delay was contrary to the interests and wishes of other investors. And there's a clear finding to that effect at paragraphs 165 and 166 of the judgment, which I'll take you to now, if I may. So 165 and 166. Page 229 of the bundle. So we see the judge there dealing with Mr Costa's personal position. He was an investor seeking a return, and he believed if the sale was deferred, he could get a better price, essentially. He knew that other investors wanted to sell. In particular, Mr Flamini wanted out at any respectable price, and those were a majority. And then you can read on. And then toward the bottom of the paragraph, from Mr Costa's perspective, almost the worst possible outcome would have been a firm offer in late 2019 to purchase the company for $100 million, capable of being accepted by the other shareholders. In other words, the worst outcome for Mr Costa was exactly what was supposed to be happening in terms of clause 6.2 and the requirement to seek a sale by that date. And in 166, the judge refers to Mr Costa's delaying tactics. Now, the fact that Mr Costa actually wasn't interested and did not want to complete a sale by the end of the year is well illustrated by the way in which he approached Jefferies. And of course, as the judge recognised, the role which Jefferies played in the exit process should have been an important one. Now, the instructions given to Jefferies was a topic on which Mr Costa's evidence was important, but fundamentally unreliable. And here we go back to the treatment of Mr Costa as a witness, which is at paragraph 118. Now, in paragraphs 118 to 120, the judge explains that Mr Costa's evidence as to the process of Jeffrey's appointment and their instructions was unreliable. So you've got Mr Costa saying he's spoken to various very large investment banks, which is the judge considered to be implausible given the size of the deal being considered, and then saying something different in a meeting with Mr Loy, giving an entirely different list of firms. So there's unreliability around the initial approach made by Mr Costa to Jeffreys. And then paragraph 119 is important. This unreliability is particularly important as regards the question of what instructions were given to Jeffreys. And here again, the documentary record is at variance with Mr Costa's evidence. Mr Costa said that Jeffreys' mandate was very clear, to sell the company from me and from the company. However, on the 30th of May 2019, Mr Di Capua, who is the company's CFO and a confidant of Mr Costa's, emailed the company's solicitor, Mr Thesing, to discuss, amongst other things, finalising the mandate to Jeffreys for the fundraise process. In other words, the evidence on that email, at least, was that what was really being pursued by Mr Costa and Jeffreys was a fundraising, not a sale. And there, I can say there were other documents referring to fundraising. Paragraph 120, I think that Mr Costa's evidence was reliable as regards matters which are documented, but I can't place any great evidential weight on his account of undocumented conversations. Then if we go to paragraph 121, the judge went on to deal with the documentary evidence. And again, the judge found it startling that there was an almost complete absence of any written correspondence between Jeffreys and its client. It seemed to me highly implausible that there was no such correspondence. In paragraph 122, it's accepted that the primary channel for such communications would have been between Jeffreys on the one hand and Mr Costa and Mr Uberoy on the other. And then towards the bottom, in paragraph 122, the judge certainly accepts that the main channel may have been Mr Uberoy, but he's less confident that Mr Costa was not copied on any of these communications. And he goes on, I therefore cannot disregard the fact that Mr Uberoy has chosen not to cooperate with the company as regards disclosure and has not given full disclosure relevant correspondence. And then 125, so there's been the judge found certainly troubling aspects of the disclosure process in respect to the dealings with Jeffreys. And then over at paragraph 125, both of the experts have said they would, if there was a proper sale process going on, they would have expected there to be significant communications with Jeffreys. And you see in 125, 3 lines down, if the experts are correct, and I can hardly conclude that both of them are wrong, there must be some trail of communications between Jeffreys and Mr Uberoy. It has not been disclosed. However, one of the core planks of the defence of the petition is that in declining to progress the sale, the company was acting on advice from Jeffreys. It is, I think, impossible to believe that Mr Costa and Mr Uberoy have in their possession documentation which demonstrates that this was in fact the advice given, but have unaccountably failed to disclose it. I'm therefore forced to the conclusion that this is not in fact what the correspondent said. So Mr Costa relies upon the notion that Jeffreys is telling him you can't sensibly proceed with the sale by the end of the year. The judge says, well, surely if that was the case, there would be documentation to that effect. There is none, therefore I conclude that that is not what Jeffreys were advising. We say that's a sound and entirely reasonable finding. In the event, there was only one substantive email from Jeffreys in the whole of the disclosure, which the judge dealt with at paragraph 73 of his judgment. Apologies for skipping around the judgment a bit, but it's paragraph 73, which is back at page 196 of the file. that's the only email that was disclosed containing substantive advice from Jeffreys. And as you see, what the judge makes of that in paragraph 74, this does make clear that Jeffreys had no intention of conducting a sale by the end of 2019 and did not envisage doing so in early 2020 either. I think the form of this update would be incomprehensible if Jeffreys were aware that the company was supposed to be trying to originate offers by the end of 2019 and that it was mandated to cause a sale immediately thereafter. I regard this fact as evidence that they were not so aware. So the email was relied upon by the judge as evidence that the Jeffreys had not been told even about the requirement of clause 6.2. And then he goes on, just, your lordships can read down through 75 and 76. There's again, your lordships will recall the conversation between Mr Minyard and Mr Balfour where the mandate was described as open. So not specifically focused on a sale.
And the board resolution from one of the meetings we looked at before was that the Jeffreys will commence the exit process as soon as the new CEO is identified.
Yes.
The new CEO is in on the 6th of September.
That's right.
And at this email, they're saying we now need a lot more time so that the new CEO is not just identified, but must be able to impact the business.
Yes.
And is there any board resolution changing its original resolution that we know of?
No. Ultimately, they abandoned the sale process towards the end of the year.
Yes.
So in that sense, yes. But those meetings are at the end of November and the beginning of December, I think. 3rd of December.
Yeah.
So it's abandoned at that point. But the most proximate meeting, I think, to this email would have been the 20th of June meeting, which was where they were told that the process was running.
Yes.
So you see in paragraph 76, the judge finds what is, however, equally clear is that Mr Minyard was not in any way instructed to meet any particular timetable. And then in paragraph 77, you see in the 4th line, the judge concludes that Jeffreys were clearly not aware of clauses 6.2 and 6.3. Yes, and indeed, my learned junior reminds me that Herbert Smith, who acted for Jeffreys, confirmed early in 2020 that Jeffreys had not been aware, not been shown and not even been aware of clause 6.2. So there's no dispute that Mr Costa never showed Jeffreys the agreement, clause 6.2 in particular, and never instructed them to achieve what was required under clause 6.2. Now, I've referred briefly to the engagement letter. Your Lordship saw previously an extract of the terms of the retainer, and I pointed out that it was much broader than a simple achieve a sale. Just for your Lordship's reference, the engagement letter is in the supplemental bundle, tab 17 at page 302. I don't need to take your Lordships to it now, but that's where it is. And the retainer is phrased in very broad terms, at which are out, as I say, go well beyond simply achieving a sale. One other point I would make is in paragraphs 157 to 159 of the judgment, is that there was some considerable focus or attention at trial given to a different, separate transaction that Mr Costa was interested in. and was pursuing, and this is dealt with in paragraphs 157, 158, and 159. The long and short of it is that when Mr Costa was purportedly pursuing an exit, he was actually negotiating to buy out one of the other shareholders in the company, namely Bay Capital, and he was proposing to do that alongside another investor called DLF. Yeah, an outside investor, so a new investor to come in and help him buy one of the existing shareholders, Bay Capital. And the particular point I wish to make is that that transaction, had it been completed, would have been entirely inconsistent with the exit process, because it would have been encouraging another investor to buy in to the company in order just to exit one of the individual existing investors.
Why is it inconsistent? I mean, there might be all sorts of other things wrong with it, but it depends on the price, doesn't it? You buy in, if you're an investor, you buy in for X and you sell for X plus 10. I mean, what's
well, at this point in time, Mr Costa should have been focusing on achieving a sale of all of the shares in the company.
Yeah.
And what he was doing was focusing a great deal of his time and attention on trying to encourage a new investor to help him buy out one only of the existing shareholders, and doing so in circumstances where the sell was that this new investor would become part of a bigger Spring Place project.
Right, it's the last bit that maybe the...
My lord, yes. And forgive me, I've dealt with this quite quickly, but it is elaborated upon in paragraph 159. Actually, before we get there, Malone Jr. points out 158. It's not just the idea that it was buying into a project that would then run and run. The actual terms of the proposal were inconsistent with an exit by the end of 2019. Okay. You see that's 158. Mr. Ubroy confirmed in his oral evidence that as late as November 2019, DLF did not know that the company was due to be sold by the end of the year. More importantly, the proposed terms of the deal with DLF anticipated that the second tranche of the purchase price for Bay Capital shares would not be paid until the end of May 2020, with a long stop date of September. And then punchline really is over in paragraph 159 over the page. You see the judge saying, clearly the sale of the company to a third-party purchaser would have made a nonsense of this strategy, the Spring Place strategy. And he also suggests that Mr Costa would not be interested in mucking Mr de Nevius around, given he's seen to be a very senior person. So we did rely upon this as showing that Mr Costa was not remotely interested in achieving what he should have been doing, was interested in other transactions. So that's the third area of the factual background that I just wanted to touch upon, and I have just had to go through it reasonably quickly. The last of the areas of the facts that I wanted to just dwell upon was the financial position of the company, because there is a suggestion, at least, that those acting with Mr Costa will want to be suggesting that the company was in some kind of dire financial situation in 2019, such that a sale at any kind of reasonable price would not have been achievable. Now, it's also the case that a great deal of financial material has been inserted into the bundles for this hearing, and again, we're not really sure how that should assist them, because the company's financial position during this period is a matter of fact on which the judge relied and made his findings. There's no appeal against those findings. So we'll have to wait and see what Malone and Friends wants to do with that material. But just so your lordships have it, the actual figures for 2019, the judge dealt with those at paragraphs 96 to 97 of the judgment. And you can see that's page 203 of the bundle. So on the 12th of March 2020, that's 2020 that should be, Mr Ringle shared the final unaudited figures for 2019 with the board. Revenues were $87.5 million, which was ahead of budget. Very important. So 2019 revenues were ahead of budget, and the EBITDA was $6 million. So, excuse me. So the EBITDA was below expectations, but nonetheless, the 2019 figure was still higher than the 2018 figure. So in a sense, still getting better, which is certainly not the impression that those on the other side will seek to give. And we get that from paragraph 45 of the judgment. So it's possibly keep one hand in paragraph 96, one finger there, and go back to paragraph 45. And you can see there that Ernst & Young in March delivered the final SID. It's not defined, but it means seller information document. This recorded that the adjusted EBITDA figures -$1 million for 2016, 2.5 million for 2017, and 5.6 million for 2018. So 5.6 2018, and then in 2019, as I've just shown you in paragraph 96, it's 6 million. So the EBITDA is moving in the right direction. It's still improving. And relatedly, one of the arguments advanced by Mr Costa at trial was that if a sale had taken place in 2019, it would have been what was described as a distressed sale, in which the shareholders would have received little or no consideration. And that argument rightly received short shrift from the judge. And the relevant parts of the judgment are paragraph 146.
Sorry, 146?
Yes, my lord.
Thank you.
And we see, this is talking about the expert report, and over the page, on page 221, the judge deals with the report of Mr Hill, who is Mr Costa's expert. And he says, however, Mr Hill then went on to pose what seemed to me to be an entirely unrealistic dichotomy, that if the sale were not deferred, the only alternative would have been a distressed sale, in which the selling shareholders would have received little or no consideration. Mr Mead did not accept this dichotomy, and neither do I, if only because the fact that at least one substantial offer was received in the period of concern would seem to demonstrate that the company was not in fact valueless at the time. And that's a reference to the metric offers, and your lordships will recall that they started at $100 million and ended up by the end of the year at $110 million. And shortly into the new year, it's $125 million. And then also paragraph 181 is relevant in this context. And on page 237, and again you see reference to Mr Hill's evidence about there being prospect of a distressed sale. Judge says, I'm not sure why he uses the term distressed. He goes on, what I absolutely do not accept is that board members in this position who elected to sell in 2019 rather than 2021 would have been breached their duties to the company. Anyway, the judge was not content to accept the characterisation that a sale would have had to have been a distressed sale if it had proceeded within the time frame provided for under the agreement. And there's no appeal from those findings. Now, of course, the company did then suffer from COVID, And really what that means is that Mr Costa's decision to delay an exit in his own interests, contrary to the company's contractual obligations, in the hope of getting a higher price, that's backfired. And the judge colourfully put this as a gamble which spectacularly failed. And the reference for that is paragraph 253 of the judgment. And that's a gamble which Mr Costa presumably now expects Saxon Woods to pay the price, which we say is wholly unacceptable. That's my review of the facts. Just touching upon one other matter, which is the counterfactual, because of course that's relevant in the context of the judge's formulation of the order. But it's important to note that the judge, of course, did consider a buyout order was appropriate. Indeed, he said it's hard to think of a clearer set of circumstances justifying a buyout order, and that's at paragraph 265. But then, of course, he applies his threshold, and he also, in his order, stipulates various parameters that will need to be dealt with by the experts. And it's probably, in terms of those parameters, it's probably easiest just to look at the order that he made, and that's at tab 12 of the bundle, page 160. There you should see the order for the 17th of April. And I'll be coming back to this, but just for present purposes, I'm skipping through to the schedule, which is at page 165. And these are the parameters which the judge states should govern the evaluation process. And the main ones to flag at this point are paragraphs 1 to 3. The judge says there would have been at least one binding offer by the end of 31st of December. So at least one binding offer. And he gives the paragraph of the judgment. And then the offer would have been for an exit within the meaning of the Shareholders Agreement. And also the company would have had at least one or two conditional offers on the table by the end of the 31st of December. So your Lordships can see the other points he makes as well. But those are the counterfactual findings, if you like, that the judge has drawn from his decision as to what should have happened if the clause had been complied with.
So he's trying to put, in essence, your client back into the position that he would have been in had the company not breached the agreement.
Yes. By these parameters. Yeah. That now brings me to Saxon Woods' appeal. Now, ground one of the appeal is in respect of the director's duty under section 172, and we argue that the judge was wrong to hold that Mr Costa was not in breach of that duty. And in my discussion with Lord Justice Snowden, I've made this point, but I'll reiterate it. I should make it clear that we do rely, and indeed we did rely at trial, on this allegation of breach of duty as a freestanding complaint of unfair prejudice, quite separate from clause 6.2. So this part of the claim is not parasitic in any way on the claim in respect of clause 6.2. And as far as it's suggested otherwise in my learned friend's written submissions, that's not correct. And the same goes for section 174. We rely upon these breaches as freestanding allegations of unfair prejudice. Now, on the basis of the judge's findings as to Mr Costa's conduct, the decision that he was not in breach of section 172 is, we say, extremely surprising, to say the least, and we say it clearly cannot be maintained. I'm taking your lordships to the findings, but I'll just give a list, if you like, of the key ones that we say are telling. Mr Costa caused the company to pursue a strategy that he knew or should have known was in breach of the company's obligations under the Shareholders Agreement. And that finding is in the judgment, paragraphs 200 and 202. The instructions that Mr Costa gave Jeffreys were not in accordance with the company's obligations under clause 6.2, and that's paragraph 214 of the judgment. And that was even though the board had approved the engagement of Jeffreys for the purposes of the exit process. Mr Costa then failed to instruct them to carry it out.
So, just give me those paragraphs again.
Yes, it's 200, 202 and 214. I'll briefly take you to them in a moment. Mr Costa knew that his instructions to Jeffreys were not in accordance with the company's obligations under clause 6.2. Worse, the instructions that he actually gave Jeffreys served his personal interests. He deliberately kept the other directors, with the possible exception of Mr Uberoy, in the dark about what Jeffreys were actually doing. He sought to close down any attempt by any of the other directors to communicate directly with Jeffreys by issuing threats. He actively misled the board by giving the directors the impression that Jeffreys were working to achieve an exit by the end of 2019, when in fact, as he well knew, they were not. He procured legal advice for the company on the false premise that he was ensuring that it was complying with its obligations under clause 6.2. And the findings in respect of legal advice are at paragraphs 86, 88 and 214. And just so you have cited these paragraphs, the key ones, paragraphs 202, 200, 202 and 214, and those are at pages 247. I did, I think, take you to certainly 200 and 202 before. Paragraph 202 at the bottom is where the judge concludes that Mr Costa was misleading the board. It's a long paragraph, but it's towards the bottom of page 248. That's the key conclusion, we say. And then paragraph 214 is where the judge summarises his position in respect to the advice that Mr Costa was obtaining, which Mr Costa, of course, had relied upon a great deal in defence to the claims against him. The judge says, I do not think that Mr Costa can rely on either of these pieces of advice. I think it is clear that he knew what Jeffreys were engaged to do, that their advice was addressed to that mandate, and that that mandate did not encompass any of the obligations imposed by clause 6.2. He therefore cannot say he believed that Jeffreys had advised him that what he was doing was in line with clause 6.2. The same is true of the advice from Sidley Austin. If Mr Costa had instructed them to advise on the basis that the company was complying with his obligations under clause 6.2, he cannot invoke that advice as supporting his belief that that was the case. So the judge debunks the reliance on the professional advice, and indeed points out that Mr Costa, the instructions Mr Costa gave were not in keeping with clause 6.2. So in short, the judge held that Mr Costa deliberately caused the company to breach its obligations under 6.2. He acted to prefer his own personal interests, and he covered this up by misleading the other directors. And yet, despite all of this, the judge held that Mr Costa was not in breach of his duty as a director under section 172. And how the judge gets to that conclusion is really encapsulated in paragraph 208, which I would ask your lordships to look at. So the judge says in 208, Mr Costa's position is that he reasonably believed that it was in the best interest of the company's shareholders for it not to comply with the requirements of clause 6.2 on the timetable that it specified, because he thought a higher value might be obtained by delaying. He knew perfectly well that at least some of the shareholders disagreed with this, and felt that their interest would be best served by complying with clause 6.2. He also perceived that his personal interests as shareholder were best served by delay. More importantly, ensured that it was him and him alone who controlled the company's actions in this regard, such that he was not merely in a position to recommend a course of action, but to ensure that that course of action was in fact pursued. However, I do not believe that it was his intention by doing this actively to injure either the company or any investor. Now, just stopping there, that's obviously not the test. The test of complying 172 does not depend upon whether you are actively trying to injure the company. I think that his state of mind might be summarised as, they wouldn't like it now if they knew, but they will thank me in the long run. Put another way, I think Mr Costa did sincerely believe that he was acting in the best interest of the company and its investors, and therefore I don't find breach. So just again, dwelling on that formulation, they wouldn't like it now if they knew, but they will thank me in the long run. That leads, we say, to the extraordinary result that it was okay for Mr Costa deliberately to mislead the board because he thought he knew best. And that conclusion is wrong for a number of reasons. First, this was not even the way that Mr Costa put his own case. His case had not been that he had kept the truth from the board for the greater good. There was no pleading to that effect, no evidence to that effect, and no submissions or argument to that effect. To the contrary, Mr Costa's case was that his actions were fully approved by the board. So this passage in paragraph 208, this is an interpretation of the facts concerning Mr Costa's dealings with the board that the judge came up with himself. And there was clearly no sound basis for the finding. I mean, the judge himself recognised that one of the more important planks of Mr Costa's case was that everything had been approved by the board. And indeed, even now in this appeal, they seek to run that case. Yet the judge found that, in fact, Mr Costa deliberately delayed matters and caused the company to breach its obligations under clause 6.2 and actively misled the board.
Which particular finding are you saying there's no reasonable basis for?
The finding that Mr Costa mindfully misled the board, essentially, because he thought it was for the best.
Where is that finding?
It's really in this formulation the judge says at the bottom of paragraph 208. I think his state of mind might be summarised as, they wouldn't like it now if they knew, but they will thank me in the long run. In other words, this is how the judge squares his finding that on the one hand, Mr Costa has deliberately been breaching clause 6.2, but on the other, and indeed misleading the board, but on the other hand has not been in breach. He says he knew he was not complying, he was deliberately misleading the board, but he did that because he thought that was the best. He knew best. That is a finding as to Mr Costa's mindset, which has nothing to do with Mr Costa's own case. Mr Costa's own case is that he was being open with the board, and the board approved everything. And really, there are two aspects. So it's important to understand this is a theory, really, that the judge has imposed on the case, as I say, to somehow square the fact that he's found deliberate breach of clause 6.2 and deliberate misleading the board, to square that with what the judge sees as the subjective aspect of the 172 duty. It effectively saying it's okay to deliberately breach the company's obligations. It's even okay to mislead the board about it, provided that in your heart of hearts, you think it's for the best.
Well, you're not taking issue, are you, with the finding of fact that Mr Costa did sincerely believe he was acting in the best interest of the company's investors, or are you?
We are. We say he was not acting in good faith in the best interest of the company. I mean, it's important one has in mind the precise formulation of 172, which is not quite the same as that. We certainly do say he's in breach of 172, which I think would include that finding.
It depends what you mean by the word sincerely. I mean, I think Mr Costa did sincerely believe he was acting in the best interest. I mean, if that is just read as Mr Costa believed he was acting in the best interest of the company and its investors, you'd say, well, maybe, but it isn't the test.
My lord, yes.
The test is you have to be acting in good faith in what you genuinely believe to be the best interest of the company.
Yes.
And it depends what the word sincerely means, because if by sincerely, if that amounts to a finding of good faith, you say that cannot be the case for somebody who knows that must know that he's misleading the board, or just he is misleading somebody who...
We get to the point where perhaps you are stuck with the finding that the judge made, that Mr Costa did sincerely think that it was the best outcome for everybody would be a sale at a higher value after the end of 2019.
Yeah, but you say you can't...
But that can't be squared with the test under 172. And I'll come on to that. There are
Elsewhere, the judge describes Mr Costa's conduct in this respect as a gamble.
That's one of the exact points we make in this regard, my lord, yes. So the two aspects really are firstly causing the breach of 6.2. And the judge found, yes, Mr Costa deliberately caused the company to breach. And the root of that view seems to be the judge's general view that it will not necessarily be a breach of duty for a director to cause his company to breach a contract if he genuinely thinks that that would be in the best interests of the company. And he makes that point at 205. So that one can see that that may be a proposition that can stand up in certain circumstances. But what it overlooks, we say, is that this is not any old contract. This was a shareholders agreement that had been entered into between all the members of the company and the company itself. It's not a third-party commercial transaction. And the purpose of the shareholders agreement is to govern the conduct of the affairs of the company, including, most relevantly for present purposes, the circumstances in which the shareholders would be able to achieve an exit. So the idea that a director could legitimately decide that the company's obligations under such an agreement should be breached is an extreme one, and we say surely wrong. And to just give a bit more legal content to that point, it's important to consider the nature of the duty in a bit more detail. So, of course, pre-2006, the duty was to act in good faith in the best interests of the company, and it was well understood that the company, for this purpose, was most closely identified with the general body of shareholders from time to time, at least in a solvent context. And that concept was preserved with the introduction of Section 172, and indeed made more explicit, because, of course, it says in terms the duties to act in the way the director considers in good faith would be most likely to promote the success of the company for the benefit of its members as a whole. So there's much more to this than simply acting in good faith. The good faith decision-making must be directed towards promoting the success of the company, and the company for this purpose is to be most closely identified with its members. And it's extremely difficult to see how a director genuinely acting in good faith and with the interests of members of the company at heart could consider it appropriate to cause the company to breach obligations that it owes to all of the members under a shareholders agreement, at least not without seeking the express consent of those shareholders. Which brings us to the second point, which is misleading the board. So not only do we have a breach of an agreement with all the members, here, I mean, even if a director considering that complying with a shareholders agreement would not be beneficial, clearly the appropriate course would be to bring those concerns to the board of directors. That would allow the matter to be considered and addressed, and possibly steps taken to liaise with the members and seek a variation of the terms of the agreement. But of course, Mr Costa did not adopt that course. To the contrary, having decided to override the requirement in the agreement that the directors work in good faith towards an exit by no later than the end of 2019, Mr Costa actively misled the board into thinking that matters were being progressed in accordance with the agreement. we say it's impossible to see how deliberately causing a breach of the agreement and then misleading the board so the breach of the agreement would not come to the attention of the members could be squared with the duty under section 172. And the judge could only have concluded that there was no breach by misapplying the test. So as a matter of legal principle, we say the factual findings of the judge cannot support his decision that there was no breach of section 172. As I've already explained, it was only by adopting an interpretation of the facts that had not even been advanced by Mr Costa that the judge was able to express the view that there had been no breach. Not only was that not Mr Costa's case, Mr Costa never said, yes, I know I was breaching it, I know I was misleading the board, but actually, in my heart of hearts, I thought it would be for the best. He never said that. Not only that, there's nothing in the judgment to really explain why he would have done that. After all, the judge has come up with this theory, but there's nothing in the judgment to explore why Mr Costa might have thought it sensible to keep it from the board, i.e. the judge doesn't surmise as to what might have happened if the board had been told, for example. So he misapplied the test, and we say the decision is clearly unsupportable.
I know you just placed reliance on the primary obligation under section 1721A. Just out of curiosity, because I've never really had a satisfactory explanation for this, but do you say that sub F, the need to act fairly as between members of the company, how does that fit our situation?
Well, it's definitely engaged, my lord. If ever it were to be engaged, it would be here. And there's no suggestion that Mr Costa did actively take them into account.
But why? It's the need to act fairly as between members of the company. I mean, I understand your point that your point is that if you have a shareholders agreement signed by all the shareholders, it can't be compliant with the duty to act to promote the success of the company for the benefit of the members as a whole, to disregard an agreement that all the shareholders have agreed to.
Yes.
I get that. That was your first point, I think.
Yes.
I get that. I mean, I understand the argument. And I'm just trying to tease out whether F adds anything to that on the facts of this case, and if so, what? If you say nothing, because I don't know what it means, then I wouldn't be
I'll do my best.
But
I mean, here, certainly Mr Loy wanted to exit. Certainly Mr Flamini wanted to exit at even a reasonable price. I think Mr Mehta had also indicated a desire to exit. Other members, notably Mr Costa, through his interests, wanted to wait out and see if they could get a better price later in 2020. So there was a disparity in views that was obvious between the investors as to what should be done. And I would suggest that fairness as between the investors would require that these matters were ventilated at board level so they could be discussed. Any actual taking into account of the need to act fairly between members, in my submission, would militate very firmly against deciding to keep this secret.
So it's the secrecy and lack of consultation.
I think that's the best. I think that's the best. The broader point as well, my lord, fairness to act as between the members must require giving considerable respect to the agreement that all of the members
Well,
have...
it's the as between words that have always rather puzzled me.
Well, you have my submission on the disparity of interests and therefore the need for matters to be ventilated at the board.
At all events, I don't think the judge actually grapples, does he, with subparagraph F of subsection 1, and I'm not sure he says anything about the good faith requirement.
I think, my lord, you're certainly right, he doesn't deal with the factors, including under F. His analysis is, if and they say so simply based on it's a good faith duty, and if I believe that Mr Costa believed that he was doing all of this for the best, there's no breach.
And this word sincerely, or this concept of sincerely believing, seems to have been introduced as part of the test in 205 and 208, without it being entirely clear what it means.
Yes. My Lords, can I move on to ground 2, which is section 174, which is the other breach of duty that we rely upon and that was not upheld below? We say the judge was wrong to find that Mr Costa was not in breach of section 174. There's an oddity here, is that the judge seemed to think that Saxon Woods was claiming both breach of 174 and separately bringing a claim in negligence. We don't understand how he formed that view, but I can show you where it appears in the judgment. So paragraph 209, you see just under where we were looking at 208, so page 250 of the file, the judge moves on to section 174, and that he deals with that all the way through to paragraph 218. And then we have a separate heading, the allegations of negligence. It is also alleged that Mr Costa's conduct of the exit process was negligent. And then he deals with a separate set of allegations in negligence. Now, maybe this is not overly significant, but we didn't run a separate case in negligence. We simply ran a case of breach of 174. Now, in relation to that claim, we argued that Mr Costa's conduct was below the requisite standard of care, and we relied upon the duty under section 174. And I should just briefly show you the pleadings. So it's tab 15, page 355 of the bundle.
Which bundle?
This is the main bundle.
The core,
The core. Yeah.
355.
Yes, 305 is the beginning of the petition. It's quite a long petition. And then we see the allegations of negligence, breach of 174, at page 355. They were introduced by way of an amendment to section 135A. And then the particulars in 135B. And you can see some reasonably familiar looking allegations under the particulars. But just before we look at 135B, 135A makes the point that Mr Costa is to be held to a reasonably high standard of care, because 174 is a composite standard which includes the standard that would be expected of somebody of your experience, effectively. And Mr Costa is an experienced person, so that's dealt with in 135A. And then 135B are the particulars. And you can see it's about failing to progress the exit process, failing to keep directors informed, including the exit committee, failing to instruct Jeffreys, and then an allegation in the way in which, much later in March 22, as to how it was dealt with through the CEO. Now, in my learned friend's skeleton, it seems to be suggested that our claim under 174 was basically focused only on the argument that Mr Costa had been pursuing some alternative transaction. Now, I've taken to your lordships to some of the material around that, and we certainly did complain about Mr Costa being focused on different things. But your lordships can see from these particulars that they don't actually form any significant part of that complaint, if any part at all, actually. So those are the complaints of negligence. You have the particulars there. Now, as to the findings that the judge made, we see that in paragraph 210 of the judgment. We just go back to the judgment, which is on page... Forgive me. Back on page 259. So the judge seemed to approach the claim under 174 as predominantly focused on the advice, the interaction with Jeffreys. As you can see, he introduces it by saying whether the director's reliance upon the advice was reasonable would depend upon all circumstances. And then in paragraph 213, we see the fact that Mr Costa relied on the fact that he was advised by Sidley, Austin and Jeffreys. Then we have paragraph 214 on page 252, which I just took your lordships to a moment before, which is where the judge says he can't rely upon that advice because he hadn't instructed them properly. So that would seem to remove the central plank of any defence that Mr Costa had to the 174 claim. However, what we then see in paragraph 215, in a single paragraph, is that the judge dismisses the claim under 174. And his reasoning is, again, simply that Mr Costa sincerely believed that he was engaging in a course of action which would ultimately be for the benefit of the company. So then he goes on, I cannot see how this can be described as negligence in the way the term is described in section 174. Therefore, no breach. But that's clearly not the correct test. It's no defence to a claim under 174 that the director thought he was doing the right thing. And then if we go to paragraph 219 in respect of what the judge seems to treat as the separate head of negligence, in paragraph 220, the judge summarises the various complaints. Mr Costa failed to progress the exit process, failed to keep other directors and shareholders properly informed, failed to inform the exit committee in his activities, failed to instruct Jeffreys on a basis which was consistent with the company's obligations, and that he effectively delayed the exit by delegating it to Mr Armbruster and Mr Ringle, who were already fully employed and therefore would be unable to progress it properly. But those are all matters that were upheld by the judge on the facts. But then again, in a single paragraph, a single very short paragraph, the judge dismisses the claim in negligence. I do not think that here is any negligence here. What Mr Costa did and the reasons why he did it are entirely clear. His commercial judgment may be called into question, but there was no neglect in his pursuit of his objectives. And maybe that's where the problem lay with the judge's analysis. He seems to essentially approaching the test for 174 in the same way as the test for 172. Provided the judge sincerely believed that he was doing the right thing, there's no negligence. We say that's even more flawed in the context of 174 than it is in the context of 172.
To adopt my Lord's question, where does this get you in terms of the jigsaw? You don't establish breach of fiduciary duty. Where do you get to in terms of the overall picture?
Well, we'd say this is another. This goes together with the 172 breach as another basis for unfairness.
So if you don't succeed on 172, do you nevertheless say you have a freestanding basis for unfair prejudice because the director did not act with due care under 174?
Well, my lord, I accept that negligence by itself would be not a strong ground for unfair prejudice, but it does go hand in hand with the 172 point, and we say the judge's decision was plainly wrong.
Do you mean it stands or falls with it?
I don't go that far. I would say that by itself it's not generally seen as a strong basis for unfair prejudice, but the fact is it's not, we say, a fair thing for a director to be locked into a company with management who are negligent.
But okay, well, now, my lord, you quite rightly got you going down that road. I mean, there's a whole host of authorities to that effect that mere mismanagement is not generally thought to be either unfairly prejudicial or certainly not to justify a buyout order. I mean, kicking off with, I think, Macro Ipswich from memory, and there is probably a lot that have followed it.
My lord, I entirely appreciate that, but it's important to recognise the way the judge dealt with this allegation, and he dealt with it in the same way as he dealt with 172, which is to say, because the Costa believed he was doing the right thing, there's no breach of duty.
Well, I can understand why you criticise the judge, but to take up my lord's question, I understand fully that you say that if there's a breach of fiduciary duty here, that is a short circuit into a buyout, because your clients will have been treated unfairly because of a breach of fiduciary duty, and they shouldn't be left locked into a company managed by a majority person, a shareholder, director, who does that sort of thing, to be very colloquial about it. But it was your more recent proposition, which is putting all that aside, let's assume there is no breach of fiduciary duty, and it is, as the judge found, a good defence to a claim for breach of fiduciary duty that you sincerely believe that what you're doing is in the best interest of everybody. If what happens is simply that a director has mismanaged the process, has operated in a way that careful directors would not, but has done so in a way that doesn't involve a breach of fiduciary duty, why, I mean, that may sound in damages, compensation, all sorts of things to the company, but why does that entitle you to say that because somebody was negligent once, that you should get a buyout order? I mean, there are company law procedures for shareholders to get shot of directors who are incompetent. Why does the court sort of dive in and suddenly order a buyout? What is the argument you have to face, I think, that my lord is putting slightly more elegantly, well, a lot more elegantly than I've just put it.
My lord, if that's all we had, I appreciate that all the points your lordship makes. But it's not, we say a finding of breach of 174 is not nothing. It contributes to the overall analysis when it comes to what would be fair and appropriate relief. And so we certainly think a decision by the judge, which we say is so obviously wrong, can't be allowed to stand and should be taken into account when it comes to the overall appraisal of what is fair and equitable. But my lord, I do take your lordship's point that if that is all we had, it would not ordinarily be seen as sufficient to mount an unfair prejudice claim.
Right. Well, shall we pause there and come back at 2:05? Thank you very much.